What sort of nonsense is this? Good afternoon, good evening, good morning, depending on where you are in the world. Don't really know where you are. Don't really care. Um, Chille filed a request for default against the state of Nevada today, and you'll notice it's not up on the screen. For a long time, people have been asking me in my Discord server and in comments, what about the state of Nevada? Does the state of Nevada have any liability? What's going to go on with the state of Nevada? And every time I've already said nothing. Nothing's going to happen with the state of Nevada because our erstwhile constitutional law scholar, Chille de Castro, forgot about the 11th Amendment. Now, I have it up here on the screen. You could read it. The judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state or by citizens or subjects of any foreign state. Now, you may notice as you're sitting here that Chille is a citizen of another state than the state of Nevada. Now, I believe this has been construed, has been read more extensively than simply, a citizen of the state of California can't sue, for example, the state of Nevada in federal court. However, I would like to point out that this is, I need to do my little thingy, share this tab instead. This is the United States Supreme Court decision from 1989. You would think that, am I sharing it? Yes. Okay. You would think that Chille would be familiar with it since he has been studying constitutional law for the last 20 years. And so when he started studying constitutional law, this decision would have been about 4 years old. And in this, the plaintiff decided to sue the state of Michigan Department of State Police et al. And the United States Supreme Court said right about down here, but a suit against the state official in his official capacity is not a suit against the official, but rather is a suit against the official's office. As such, it is no different than a suit against the state itself. And neither a state nor its officials acting in their official capacities are persons under Section 1983. He cannot sue the state of Nevada for money damages in federal court. Now, his cause of action, he had, I'm going to say two. He had more, but he essentially has two causes of action against the state of Nevada. Cause of action number one is a Monell claim under 1983, and the Monell claim is expressly you can't do it. The second cause of action is a collection of various state tort causes of action. And the problem with state causes of actions against a state is that specifically, unless the state waives sovereign immunity specifically for that cause of action, you can't sue the state for it. And the state of Nevada has not waived its sovereign immunity for actions about assault, battery, kidnapping, etc. So, in summary, Chille filed the lawsuit against the state of Nevada. They had 21 days, I believe, to respond. It's 30 in California. I think it's 21 days in federal court. Maybe it's a little longer. Don't know. Don't really care. They did not respond in time. So what Chille's done is Chille's requested a default. A default is different and distinct from a default judgment. A default judgment is where you get paid. A default is where the court just says, you know what, you can't answer anymore, defendant. The time for your answer is passed. Now, if the state of Nevada still wants to get involved in this, even though they won't ever have to pay out a dime on any of this, if they want to get involved in it, then they can still file a motion to set aside the default, and the court will most likely grant it. But the state of Nevada is completely immune from all of this. And so that's why it was such a big joke initially. And I was really just waiting for Chille to get around to, I don't know, reading the 11th Amendment and thinking to himself, how can I sue Nevada since I'm the citizen of another state? How can I? But he never did it. So here we are. All right. So now we're going to do the humiliation ritual. Yes, it was short, but it's such a simple solution that I can't really make it much longer. I'm going to have to watch this pantsless in solidarity with your dick in your hand too, sir. Where do you think my right hand is right now? Hello, Beck and Hollow. Pants off, cocks out on 34th Street every day, all day. Dinatella is still using his, quote, special, end quote, hair treatment. I don't know what you're talking about. And your nickname for Chille is pretty lame. Good God, man, I beg of you, introduce me to Shiz. Shiz, this is Kevin. Kevin, this is Shiz. Ha ha ha, he shaves his knuckles. Well, I mean, wouldn't you? If you were going to give yourself a stranger, wouldn't you shave your knuckles first? This is going to be fire, as always. Well, thank you, Corrections. I appreciate the show of support. But hairy knuckles are better in the rape cage. Well, you know, I'm sure you're aware of what's better and not. And, you know, I'm not going to kink shame you. Let's see how loud his cock gets this time. Believe it or not, usually they're pretty quiet. So I don't know why, but sometimes when I start, they all start gathering around and crowing, but thankfully not now. It's 7:30. No, I don't recognize time zones. Game time, Chille equals Cheswick from Cuckoo's Nest. Okay. Merb, hand, purple, blue, peace. Okay. Merby. I heard the state of Nevada was curled up in the fetal position, lying in a dark room in fear of Chille. Well, you probably heard wrong. Yay, it's the Merbmeister. Okay, I turned very Germanic for some reason. Are you worried Chille is going to sue you next? I tried. Chille alluded to me potentially being sued if I got over 4,000 subscribers. Thank you to all the Karens from Kate. She had all of her Karens come over and subscribe. So, you know, yay, I'm well past 4,000 and no lawsuit has ever been filed. So I am not worried, and I am somewhat disappointed that he has failed to sue me. It would have been, I think, a good time, but, you know, your mileage may vary. Denied, dismissed, denied, dismissed. Well, that's wishful thinking. Chille's terrified of lawyers. Every single case he's in, he's up against lawyers, so I don't think he's terrified of them. And judges are lawyers. Where's the chickens? They're around. It's been pretty hot, so like they tend to lie under the shade, like along the house, places where the dirt is a little bit cooler, where it doesn't get a lot of direct sunlight, so the dirt stays cooler and they flatten themselves against the dirt. Clearly, indeed. I will love to see that idiot sue Merb. I am sure he's not worried. No, I am not worried. Cock-a-doodle-doo to you. A chicken in every pot. Someday. Cock-a-doodle-doo. Hello. Mexico is suing gun manufacturers in the 1st District. So you can be sued. A state can't be sued by a citizen of another state. But you and corporations can be sued by foreign entities in federal court. Beast Mode Jedi. Merb, do you think Chille's mom ever wishes she had swallowed him instead of letting his dad squirt him into her? I am sure that as a mother, she loves her son, and she's very proud of his accomplishments, and she is probably not very happy of his setbacks. Circuit. None of Chille's false copyright strikes have stuck. It's almost like he's a natural born loser. Well, weirdly enough, let's do this because I still have one. Content, videos, filter, and there you go. Oop, share this tab instead. So you can see Chille bait right here is still removed. Now, I don't know why. I was never named in the lawsuit. They said, hey, you know, he showed this lawsuit and he said that you're a defendant. And I'm like, well, obviously my name's not listed anywhere on the lawsuit. And now that lawsuit's been dismissed and it's still struck. So I don't know. I think YouTube is pretty damn shitty at dealing with copyrights. And maybe I should sue them. I don't know. Don't tell Chevy, Merb. I don't know what that means, but Forge the best. Hey, don't know, don't care. Great motto for a law firm. Do we cheat him and how is the best one. And I always care when it comes to money. Congratulations, Sergeant Rock, on the recent win. Congratulations, I guess. Clearly, he must refile. I think in Massachusetts he does. Clearly. Chille has been extremely quiet about all this. Well, good for him. I hope he learned to shut up about his lawsuits. Clearly, because it never helps him when he talks. Chille wins. Why does Chille win? Smash that like button or not, whatever. No, he doesn't. Chille needs to give up. That chili powder is frying whatever's left of his little brain. Governor Castro is busy raising money for violent criminals. Yeah, well, good luck to him. Damn, I finally made a live stream and it's over already. Well, you know what? Short and sweet. That's my motto. That's why I keep telling the ladies anyway, and then they laugh and laugh and laugh. What if kink shaming was my kink? Well, then I wouldn't shame you for kink shaming. Commentus interruptus. Hello, love when your rooster chimes in on your stream. Well, you're one of the few. You filed a second motion today. If you want to continue, appreciate your coverage. You filed a second motion today. Well, let's check it out. A little on the fly, just so you can see. Oh God, a motion to partially strike defendant's answer. All right, this is DeCastro versus LVMPD. He moves his court to strike portions of defendant's answer and to have responses in the answer deemed admitted. Well, I mean, shoot for the stars, Tiger. So we're going to have a memorandum of points and authorities. Defendants have filed insufficient defenses to plaintiff's first amended complaint and moves this court to strike under Code of Federal Rules of Civil Procedure, Rule 12F2. They have not answered the allegations in good faith. Interesting. That's gonna be a long road to hoe. Alleging a denial isn't in good faith. All right. Defendant's first affirmative defense isn't even an affirmative defense, as it's a negative defense. Courts in the Ninth Circuit have found that negative defenses, such as a failure to state a claim, to be an improperly asserted affirmative defense. A 12b6 can be included as an answer or on its own motion. So I'm not sure what he's going on about there. Darn flies. All right. 12, Rule 12, defenses and objections. All right. Every defense to a claim for relief in any pleading must be asserted in the responsive pleading if one is required. But a party may assert the following defenses by motion. So 12b6, failure to state a claim, may be asserted by motion, but it must be asserted in the responsive pleading if one is filed. So let's look at J&J Sports Products. Oh, Jesus Christ. In the Eastern District of California. All right. All right. Plaintiff filed a motion to strike the affirmative defenses pled in both answers. Plaintiff requests court sanction defendants for filing inappropriate and irrelevant affirmative defenses. 12F court is permitted to strike from a pleading an insufficient defense or any redundant, immaterial, impertinent, or scandalous matter. The defense may be insufficient as a matter of pleading or as a matter of law. An affirmative defense may be considered insufficiently pled where it fails to provide plaintiff with fair notice of the defense asserted. An affirmative defense is insufficient as a matter of law where there are no questions of fact, that any questions of law are clear and not in dispute, and that under no circumstances could the defense succeed. That would be like if you're pleading an affirmative defense of barred by the statute of limitations. If you're in agreement as to when the particular issue happened, when the alleged wrong took place and what the alleged wrong was, well, then you just look up the statute, and as a matter of law, you know, either the statute of limitations applies or it doesn't apply, and if it doesn't apply, it can be struck. Wait, where are we looking at in here? He says pages 4 to 5. Defendant's first affirmative defense asserts that plaintiff fails to state a claim. Failure to state a claim is an assertion of a defect in plaintiff's prima facie case, not an affirmative defense. Accordingly, defendant's first affirmative defense for failure to state a claim is stricken. Okay. Interesting. You know what? Let's look. All right, we're going to go to D. Castro versus LVMPD. Share this tab instead. There's the amended complaint. There's the answer. Well, don't we have a motion to dismiss already? I thought we already had a motion to dismiss. Yeah. And this one alleges failure to state a claim, right? Let's just do it this way. Failure. The instant motion seeks to dismissal of the majority for a failure to state a claim upon which relief can be granted. So, okay, so theoretically he could have that part stricken. Sure. I don't think it's really going to do anything because there's already a motion on it, but okay. Defendant's second affirmative defense. This merely alleges defendant officers had probable cause to arrest plaintiff. Courts in the Ninth Circuit don't require affirmative defenses to be pled under the heightened requirements of Twickball, but the affirmative defenses must give the plaintiff fair notice of the defense under Connolly, including sufficient facts and grounds. Here, defendants' pleadings are completely insufficient to meet that requirement. Defendants don't specify which law was violated, which facts would have granted them probable cause, and clearly it wouldn't apply to all the officers. Okay, well, let's look. Why are we so small? I want to get out of that one. I want to go back down to the answer. Make it big, big boy. All right. Defendant officers had probable cause to arrest plaintiff. If one defendant officers had probable cause, then they all would. The defense was justified. I think that one will stand. I'm going to go with that one will stand because it puts them on notice. It pled facts sufficient to place them on notice of what is the affirmative defense is. The affirmative defense is they had probable cause. If they had probable cause for the arrest, then it's not an unlawful arrest. All right, now where are we at? Third affirmative defense. The complaint acts of these answering defendants were justified and privileged under the circumstances. Yes. So justified, i.e., they were acting in good faith, right? So they were justifiable. They thought they had probable cause. If they didn't have probable cause, they thought they had probable cause. They were acting on that probable cause or thought of probable cause. And so just because an officer makes an arrest that is later found to be without probable cause doesn't mean that that you can sue the officer and win necessarily. It doesn't necessarily mean that. Officers are allowed some wiggle room. If the officer has a good faith mistake, makes a good faith mistake of fact, or weirdly enough, of law, and this was a case out of, what was it, North Carolina or something like that, where the officer thought you had to have 2 working brake lights. And so he pulled over somebody, and it turns out they were running drugs or whatever. The U.S. Supreme Court said that it was reasonable for that officer to believe that you needed 2 working brake lights, 2 working taillights. And so, yes, a good faith, reasonable mistake of facts or law is justifiable. I think that one stands. Or did I miss one? Did I miss one? Third affirmative defense. So it doesn't really say, this one doesn't really say what the justification and privilege was. There are privileges under state law for police officers to make arrests. So that might be what it's referring to. It could, in theory, get struck. The fourth one we already covered. You can make a good faith mistake of facts or law. Fifth one is qualified immunity. They have qualified immunity from the actions alleged to them. It specifies what actions. The actions specified are the ones alleged against them in plaintiff's complaint. That one will stand. Defendants merely allege NRS Chapter 41 limits the damage of LVMPD. Defendants don't say how state law applies to plaintiffs' federal claims or to which claims they're applying it to. Well, it'd be the state law claims. It's like $100,000, I think. Nevada limits these kinds of things to $100,000. Oh, hold on. I'm not flipping back and forth well enough. So that's what I just read. The sixth one is, yes, $100,000 is the maximum for state law claims. And then, Jesus Christ. So $100,000 is the maximum. Defendant's seventh affirmative defense. Merely alleged plaintiff's First Amendment complaint concerns a discretionary function of the LVMPD defendants for which defendant LVMPD is immune pursuant to NRS 41032. It's the state law claims. Defendant's ninth affirmative defense. Defendant's ninth affirmative defense isn't even an affirmative defense. It's a negative affirmative defense. Well, let's look at the ninth affirmative defense then. Where's the eighth affirmative defense? They must have shit-canned the eighth affirmative defense. Plaintiff's claims of constitutional violation is unsupported in both fact and law. This plaintiff has not alleged sufficient basis from which a constitutional interest might arise in conjunction with the alleged actions. That's where he was alleging that he was being discriminated against on being a reporter. They went over that above in the pleadings. That's what they might be doing. They might just be summarizing what they were talking about up in, or maybe they talked about it in the motion to dismiss. Yeah. So I think he's referring to various things that he alluded to or he raised in the motion to dismiss for failure to state a claim. 10th, claim is a claim of negligence on the part of the defendants. Is a claim of negligence on the part of the defendants. A claim of negligence on the part of the defendants. Well, let's take a little look. Any injuries are allegedly sustained by plaintiff for the result of his own negligence. Oops, share this tab. Result of his own negligence. I think he got confused in there. Defendant's 10th affirmative defense is a claim of negligence on the part of plaintiff. I don't think that one's going to get struck. Okay. 11th affirmative defense is a claim of negligence on the part. Wait, did I skip one? Oh, yeah, I did. I skipped one. To the extent, so the 1983 covers intentional acts. A 1983 lawsuit is for intentional things. You have to intend to strip the rights from people. I have to let the dog in. A 1983 lawsuit, again, is not for negligence. You're not suing someone for negligence. You're suing them for an intentional act. It's like the difference between personal injury action, saying that your negligence caused me harm, versus an assault action where you struck me, you intentionally struck me. 1983 requires intent. It can't be for negligence. So that makes perfect sense to me. And then any injuries alleged. So that covers that one. So that was my mistake in reading it. My apologies, Chille. So defendant's 11th affirmative defense is a claim of negligence on the part of plaintiff. Defenses regarding negligence on the part of plaintiff are only applicable in negligence, contract, and copyright infringement, none of which are alleged here. Defenses regarding negligence on the part of the plaintiff are only applicable in negligence, contract, and copyright infringement. Oh, you want to see what I'm looking at? This is what I'm looking at. And I'm going to search Google for it. Interesting. So he didn't cite it, but there it is. I don't know if it's true. This is an Eastern District of California case. Okay. Why are they? What is going on here then? Let's see. I want to go back to here. No, I want to go back to here. It's quite common to plead. Where's the First Amendment complaint? It's quite common to overplead defenses. Most answers I've ever seen have overpled affirmative defenses. It's very unusual to move to strike them because it costs time and money. Let's see. We're looking for negligence in here. Well, gosh, Chille, are you pleading negligence? There's one negligence. There's a cause of action for negligence. Huh. Uh-huh. Okay, let's see. Negligently or recklessly. Freaking weird. That's weird. 11th affirmative defense is a claim of negligence. Defenses regarding negligence. See, that's why you shouldn't just like copy out of J&J Sports Products versus Montanez, because it took me, what, 10 minutes to figure out that you'd pled negligence? But you pled it, you dummy. All right. 12th affirmative defense is a negative defense. All right, let's go back to the answer. You'd think I would just have all of these open, but I don't, because I wasn't really prepared to respond to this. All right. Number 12. Lucky number 12. Plaintiff cannot recover punitive or exemplary damages because plaintiff has failed to plead and cannot establish facts sufficient to support allegations of malice, oppression, or fraud. Plaintiff is not entitled to recover punitive or exemplary damages herein under any of the claims of relief alleged, as none of the LVMPD defendant supervisors, directors, or managing agents committed the alleged malicious, fraudulent, or oppressive acts authorized to ratify such wrongful conduct or had advanced knowledge of any of the unfitness of the employees, yada, yada. Okay. Let's assume, for the sake of argument, that is a negative defense and not an affirmative defense. Won't change anything if it's struck. 13th, another negative defense. Well, let's look at 13. Failure to plead with particularity. Essentially the same as a failure to plead with particularity. Well, let's go back to this. I don't know why he says that would be a negative one, but let's assume it is. Let's assume they strike it. Still doesn't matter. Not going anywhere. All right. 14th. Defendant's 14th affirmative defense is a claim they weren't negligent in supervision. This defense provides no notice to plaintiff of how defendants were not negligent. That's like saying I wasn't speeding. Well, you're not providing me notice of when you were not speeding. Interesting. Well, let's look. Okay. I don't think that's getting struck. Even if he does claim it was no, he doesn't claim this was a negative. He doesn't claim it was negative. But yeah, I don't think that's getting struck. Defendant's 15th affirmative defense is the attempt to reserve affirmative defenses. Oops, you didn't see that one. Yeah, I see this a lot. I don't think it matters. At least in state court, you can amend your answer or complaint liberally, and you one common thing is at trial to ask the court to amend your initial pleading according to proof, and I have seen it granted. So there you go. All right. Anything else? Responses deemed to be admissions. Averments, obviously within defendant's knowledge, should be deemed admitted. Under Federal Rules of Civil Procedure 8B1B, a defendant must either admit or deny allegations asserted against it. Separately, a party that lacks sufficient knowledge or information sufficient to form a belief about the truth of an allegation must so state, and the statement has the effect of a denial. On the other hand, a party may not assert a lack of knowledge or information if the necessary facts or data involved are within his knowledge or easily brought within his knowledge, a matter of general knowledge in the community, or a matter of public record. A denial of knowledge or information in this context casts a doubt of the good faith of the pleader. Furthermore, a federal court will often impute knowledge of certain matters to a party, such as charging a corporation with the knowledge of the acts of its agents, or will impose a reasonable burden of investigation upon the pleader. All right. This is a publication. See also this district court case. He's loving these district court cases. Boy, he found district court cases, and he's all over it. Denials of allegations clearly with the defendant's personal knowledge or in the public record are not credible and violate their obligation under Rule 8b. An averment will be deemed admitted when the matter is obviously one as to which a defendant has knowledge or information. A defendant failed to examine available, highly relevant government documents which would have given a basis to respond. An alleged lack of knowledge is not sufficient to constitute a denial because information as to the allegations in the particular number paragraph was reflected by public record, and the defendants could have obtained definite information as to the truth of the allegations in that paragraph. Prior to denying an allegation for lack of knowledge, the defendant has a duty to exert reasonable efforts to obtain knowledge of a fact. Defendant must perform reasonable investigation to obtain the knowledge of such fact prior to denying it. For example, a defendant may not fail to undertake even a minimal examination of their files to determine the truth of an allegation. Relying on these principles, courts around the country have rejected denials for lack of knowledge where a defendant obviously has knowledge or easily could have obtained knowledge of the situation, yada, yada, yada. I don't know what he's citing this from, but awesome. Awesome. Here. Okay. First Amendment complaint 20, 21, 35, and 44. (20, 31, 35, and 44). All right. All right, buddy. First of all, we're going to do this. We're going to download this, save, and open. And then we're going to go back to, where's the First Amendment complaint? Complaint, motion, order, amended complaint. All right. Download and open. All right. Can I do that? Boom, 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 boom. Oh, too big. That's what she said. Boom, boom. All right. 20 and 21. Let's take us a little peeky poo. Share this tab instead. At approximately 4:30 p.m. Pacific on March 15th, 2023, plaintiff happened upon a police interaction between a woman sitting in a silver Hyundai Elantra and Bork, who was sitting in a Ford Police Interceptor with the LVMPD logo on it and the number 19084. Plaintiff does not know the woman's name, but will refer to her as Jane. Well, so one of the issues with shitty pleading, and this is what you're going to get, is when you include multiple things into a single bloop, into a single paragraph, into a single number, where you give defendants lots of leeway. If any one of those things in there, if the defendants don't know the answer to it, they can plead as to the entirety that we don't know. Now, do the defendants know whether or not Chille knows the woman's name? I'll give you a few minutes to figure it out. Was it or is it available in a, what was it, public record? No. And just because a video has been published to YouTube does not make it a public record. So there you go. That is not a, so it has to be, back to this, clearly within the defendant's personal knowledge. Personal knowledge. That's what you know. That's what you've seen yourself. Like, I was there. I have personal knowledge of this instance. Or in the public record. Like, I went to the county recorder's office and I looked up the deed. It's in the public record. I went to the law library and I looked up the complaint or whatever. It's a public record. It's court cases are public records. Statutes, laws are public record. Legislative hearings are public records. County recordings are public records. Personal knowledge or public record, i.e., not a YouTube video. So, going back to this, no one fucking knows but Chille. No one has personal knowledge of whether or not Chille knows the woman's name. Okay. Number two, plaintiff started recording the police interaction on one of his phones, moved to a position approximately 10 feet away from Jane, and making sure not to come between Bork and Jane, he asked her if she was good. Are you okay? Do any of the defendants have personal knowledge of whether or not Chille was making sure not to come between Bork and Jane? Is it a matter of public record? Fucking stupid. All right. What else were we looking at? So that was 2020, 35 and 44. So let's go to 35. At some point, defendant Tori, the supervisor, arrived on the scene and authorized the defendant's behavior as being within their policy. Was that filmed? Was that part filmed? Do the defendants have personal knowledge of it? Well, then no. I guess they would have personal knowledge of that. Do they deny that, or do they not deny that? And under what basis would they not deny that? So what are they looking at? All right, so that's 35. What are they looking at? At some point, defendant Tori, the supervisor, is he the supervisor? Arrived on the scene and authorized the defendant's behavior as being within their policy. I mean, it's vague. I could see why they might be saying it's vague, being within their policy or LVMPD policy. I mean, I could make an argument for it. And what behavior See, it's poorly worded. So Tory then said the plaintiff should be arrested to discourage plaintiff from videotaping police stops or from interfering in police stops. So I think maybe what the reason why they answered that they're without sufficient knowledge to form an opinion is because of, again, how poorly worded the pleading was. That it doesn't clearly state which behavior that they're trying to discourage or which policy the defendant's behavior was within. And then 44. Following the incident, Bork claimed in a written incident report that the reason why plaintiff was arrested was for engaging with a detained driver, refusing to give an officer reasonable space to work, and refusing to obey lawful commands after being advised he was detained. There you go. A detained person's rights are only limited as to leaving. Well, I don't know why they would answer that they're without sufficient knowledge. I would argue that it contained a legal contention. A police officer, specifically defendant Bork's feelings about lawful behavior must be weighed. Again, this is another legal contention, but I can see why he answered the way he did. The defense behavior did not follow LVMPD's use of force policy in interactions with public policy. This is, again, I'm going to guess that'd be a legal conclusion. And also it stands in stark contrast, again, to defendant Tory saying it was being within their policy. And it also cuts directly against his Monell claim against LVMPD. All right. Any more in here that we need to cover, or was that the end of it? That was the end of it. There's the conclusion. I don't think all of the affirmative defenses will be stricken. I think he might get a couple of them out. Doesn't really change much. Doesn't really change anything. And then I don't think any of these are going to be deemed admitted. And that is where I am at on that. All right. Now, where were we? I'm working on an important case right now. Nice. Case of beer. Gotcha. Who was the knucklehead that started the myth that roosters only crow in the morning? I don't know, but whoever it is was 100% wrong. Are you still advocating for let drunk people drive with no punishments? I don't think it should be illegal to drive drunk. I think it should be illegal to harm other people while you're drunk. So yeah, and I don't fucking care that you disapprove of it because it's my opinion and you could suck my dick. Late again. Well, better late than never. It was probably Chille Sergeant Rock. After all, he's a 20-year constitutional cock scholar. Yay, cockadoodle doo. Vote for us in the Grifties group category. We're number 22 present. You're not the real Welsh News Now. Or what is that? Welsh News Network. That's what it is. Merb's cock sounding glorious as always. Thank you. I can see clearly now, but after a few more, nice. Merb's cocked is at it again. Rocked, cocked, and ready to rock. Locked, cocked, and ready to rock. Merb, has Chille ever won any of these lawsuits? He has not won any lawsuits to date. Love the cock. You need a hobby. Well, you're the one watching my stream, dude. If you don't want to watch my stream, then don't watch my stream. Hey, Merb, do you think Chille's plan for his LVMPD arrest is to go to trial and try to nullify the jury? Try to convince the jury to vote against the law. I wish him the best of luck with that. Jury nullification is usually referred to. What is it with the flies out here? I swear I'm super sweet today or something. Jury nullification is usually referred to in terms of criminal proceedings, where you can try to convince a jury to, despite the guilt of the defendant, to find him not guilty. And typically that's done in cases where the law is perceived as being unjust. Nice touch reaching out to us. Ford, for only real deer hunters. Okay. not a huge deer hunter fan. I've hunted deer, but it's not really my gig. Fuck it, we'll do it live. There you go. Burb's going to overtime. Yeah, for more pay. Bonus motion. I meant the ones he struck me with. Would you rather be skanky, wanky, or hoe? Yes. I, for one, love the chickens. Smash that butt done. Meow, sick a diddle woo. Has he just defeated his own argument? Probably. He does that a lot. Chille's law vomit hurts my brain. It hurts everybody's brain. I got bit by a brown recluse spider. I usually love the outdoors, but come on. I thought brown recluses were usually an indoor spider. Sorry that it bit you. I hope you feel better. Where did it bite you? Can you tell which rooster is crowing by the sound alone? Yes. Well, usually, I should say. Merb, do you admire how many motions, etc. Chille is creating nearly every day? No. Filing useless motions is a waste of time, which is why most times attorneys don't file motions to strike affirmative defenses that are unmeritorious. It doesn't hurt you to leave them in there. You go to trial. If they don't prove the things they need to prove for their affirmative defense, then they don't get the affirmative defense. I mean, either the affirmative defense is effective or not, so this is a wasted motion. It's not going to change the outcome of the case. And theoretically, I guess the defendants could seek leave of court to amend their answer and really fuck with Chille. So wouldn't that be fun? Merb got a second win. Did you hear me fart? Is Chille handling Jason Dollar Ride's lawsuit? I don't know. I'm not up to date on Dollar Hides, I think his name is. I'm not up to date on his lawsuit. I'm sure it's an amazing lawsuit, though. What's up? Hey there. Clearly, Chille is a wickedly gruesome plebeian and a belligerent, blood-freezing derelict whose birth certificate is an apology from the condom factory. It's kind of mean. What's up? This doesn't sound like Chille. Has he got someone else writing his motions? No, it's copy-paste. It's copy-pasta. I hear make it big boy all the time. Lifetime of disappointment. I hear you, brother. I hear you. Have you always had such an amazing memory? Your recall of cases blows my mind. I don't have an amazing recall of cases. So I have a general recall of general cases, but you get some of these people, like people that only practice family law, and they'll pull cases out of their ass, and you'll be like, shit, I need to look that up. But they'll be talking to the judge like everybody knows this particular case, and you're like, God damn it, like I need to figure out what that case is. So the more you specialize into, or the more work you do in a specific field of law, the more comfortable you get with cases. Yeah. I think a big part of being a lawyer is having a good memory. No. The research, the thing that separates a lawyer from the layman is that a lawyer knows what he's looking for, and so he can research it, if that makes sense. Laymen don't always understand what they're looking for, and they misunderstand words, and so they go looking for the answer, but they don't find it because they don't know what to look for. And there you go. This was a hilarious long troll. Okay. Let the rooster talk. He can talk whenever he wants. In fact, right now, Indigo's just staring at me for some reason. I don't know. That's how it is in the UK. If you have one, it must work. Oh, wait. Hold on. And North Carolina also changed the law wording after that. So if you have two brake lights, they both have to work. Okay. Yeah. There you go. What was that? Heinz? I forget the name of it. If you have one, it must work. There you go. If you have 10 brake lights, all 10 must work. Can't you use hand signals? Yes. Yes, you can use hand signals, but I don't think they replace the brake lights. I'm late. Have the roosters out of their thoughts yet? Yes. There they are. There you go. Lowell just skipped number 8. During the day, hand signals are legal. Oh, Merb with the summer cut. Rico Suave. I'm late. What's this? This is called a live stream. Who let the dogs out? Technically, I did. I'm only here by special appearance. Welcome. That officer accidentally struck Chille in the nuts. Yeah, according to Chille. Hiya, deletes, imposter. Merb looking sharp with the fresh trim. Thank you. And any appearance you make is by definition special. He's a good delete laws. Does any of the body cam footage show Chille getting punched in the clackers? Not that I've seen. But you have to remember that cameras only capture what they're pointed at. And sometimes things happen outside of the frame. So just because the camera doesn't capture it doesn't mean it didn't happen. The long pregnant pause is brought to you today by bourbon, the stuff that makes Merb tick. I have not had any bourbon today. I wish I did. I might have a glass later. Join me, Merbeast, and together we can rule the galaxy. There you go. If it's Chille, he'd be suing everyone, even to chickens. They neglected to acknowledge Chille as a constitutional law scholar and therefore superior to everyone on the planet. Nope, not on video. That's a lawsuit. Tanks delete laws. You're not Merb's father. That's impossible. I was hatched. Search your feelings. You know this to be true. The only legit plea is insanity. Okay. I'm assuming that's a joke. YouTube channel named Artie's Corporate Fiction has all the body cam footage. Vids. If there's no video, it's Chille's lies against the officer, or would he be bold enough to produce a medical report for his brutalized balls? Eventually, if he claims injuries, he's going to have to show something to back him. I filed one against you and it went as far as all your suits did. You'll get better. Hi, Merby. LVMPD is negging. They're guilty of negligence because they neglected to acknowledge Chille as a constitutional law scholar and therefore superior to everyone on the planet. When it comes to Chille, I suspect the cops, even if the cops messed up. As a constitutional law scholar, I approve this live stream. Chille's punch in the nuts means search incident to arrest. Yeah, they probably groped his ball sack area to see if he had anything hidden there. Chille is the Napoleon of constitutional law scholars. Actually, more like the Ross Perot. I liked Ross Perot. El Bandito is the special needs kid of the constitutional law scholar. Merb, get to the facts. He's the Eric Cartman of special constitutional law scholar Olympics. Is this the famous two negative defenses don't equal an affirmative defense? Maybe. Merb's got the whole old school James Freeman beard growing out nicely, though. I'm trying. You know what? Let's give you a full screen, baby. Full screen. Yeah. Look at that beard. It's comical. I recently realized the next town over has DeCastro Road. The only thing I know down that road is the landfill, which seems appropriate. Clearly. Quit picking on Chille. I know. Whoa. Easy with the anti-Semitisms. Easy with the anti-Semitisms. That defense is second in invincibility to the nuh-uh defense. Whew. Easy on the anti-Semitisms. Howdy. Yes, closely followed by the precedent-setting nope defense. Chille never got to be a Power Ranger. Yes, he did. He was a Black Power Ranger in an unaired episode, wasn't he? And now he needs to pretend he is to be where he is to save someone. Okay. 20 left. I'm hurrying. 30 pack or from the resisting. Sue me. Delete laws before I end my case. I already filed the judgment against you. I'll plead for a fifth. A fifth of what? You know how charming and persuasive Chille thinks he is? I do. At what point does he become a vexatious litigant? As soon as someone files a motion and convinces a court that he's a vexatious litigant. It doesn't just happen by magic. I'm here and you're not. That's true. Hi, you're dumb. Thanks. That was it. Have a great day.